back to the show. This is The Law Show on CL 650.
And welcome back to the show on CL 650. Welcome to the second half of our Wills and Estates show, but we're also going to weave in family law because we have Leah Donaldson here, Senior Associate at McQuarrieHunterLLP. And why don't we recap again what your specialties are there at Macquarie? So what do you deal with? What percentages do you think you have in each camp?
So I think I do about 40% family law, and that's sort of, I do the solicitor work and the court work for family law, and then about 60% estate litigation, which is the disputes that can arise relating to wills and estates.
Now, are you unique that you do these two, or is this a common cross sort of practice?
It's not that common, but there are a few other practitioners that I've noticed around town that do the same sort of crossover. And I mean, I think they're complementary areas, so it works for me, and I think it's probably going to be a growing area in both areas, so estate litigation and family. So
how are they complementary? Because I kind of see it, but I maybe share that with us.
Right. So one of the main ways I would say I see the two areas intersect is what we were talking about earlier in the show, where the wills variation legislation. So it used to be called the Wills Variation Act. It's now part of WESA, allows for a spouse or children to apply to the court to vary a will. Now, if it's a spouse, say, is the claimant in court to say, I don't think that my spouse left me enough money. So say the testator or will maker, now under WESA, has $1 million estate, and they leave a will and it says, I want to leave $1 to my wife. They are allowed to do that. You're allowed to make whatever kind of will you want, but then your spouse has the right to apply to say $1 is not good enough. One of the main considerations for the court in that circumstance is what the legal and moral obligation of that will maker has to that spouse. And the way we calculate the legal obligation is what that will maker would owe that spouse if they had a divorce. So because they have to have a way of breaking down what that person should pay, essentially.
And that's interesting because I know from having you on other shows is there are calculations for that, right?
Exactly. And so we see it's becoming more and more common that judges are saying, okay, well, I have to figure out what's fair for this spouse. So I'm going to look first at family law legislation and what they would get if they had divorced. Calculate that. So we would go back and what would they get if they divided their assets, spousal support, all of that would come into play.
And then that is complicated yet again if they were a homemaker and they didn't work, they gave up their earning career to stay home and look after kids, right?
Exactly. So we see a huge chunk of family law analysis being sort of inputted into the wills variation dispute matters. So that can be quite, a large part of how they determine that. Now, at the end of that analysis, the judge then says, but this wasn't a divorce. This was a death. These people stayed together. So obviously there's an additional obligation, and that's what we call the moral obligation.
And can that be large or is it capped?
It can be. None of it is capped. It's all based on several factors. So if it's a $5 million estate, the amount that's paid to a spouse is going to be different. So if it's a breakdown and they do the calculation of the legal obligation, and then they say, but there's still a moral obligation over and above that, that will be a different amount than if the estate is only, say, $500,000.
Okay, so you've got this person that's got $1 million and they're married. How is that even possible that it's still separate? Because you're only allowed to get what you, in a divorce situation, what you had as joint or what has grown inside that marriage, right?
Correct, yes.
So how could somebody have $1 million outside of a marriage? They brought it to the marriage, is what you're saying.
Well, it's just the will maker's assets at the time of death. So because the analysis is a bit different. So you're saying, well, it's part of the assets that are at play, but we're saying it's not a divorce. It's the assets of just the will maker. That doesn't mean that there could have been other assets that passed to that spouse that were jointly owned. Because they're, if you're married, maybe you owned a house between the two of you, and that spouse got that house on death by by right of survivorship. So the title passed.
Joint bank accounts, all those sorts of things.
All those joint bank accounts
that goes automatically.
That's right. What's left is the estate.
Okay.
And so that spouse can still say, even though I got all of this outside of the will, that isn't fair. I still need more of the estate. And that's how that claim is made.
So this person might have had shares in a business or something like that.
Yes.
I see.
Anything that's registered in their sole name would go into their estate.
Okay. Now, what happens, I know this for family law, is when a divorce happens, the debts that the spouse incurs, racks up credit cards, buys cars, whatever. When you divorce, you're on the hook for your spouse's debts. Now, in the situation as we just described, so one person has passed away, and they still, after the joint items like the house and the bank accounts have gone over, and then they have debt outside of joint. Are you on the hook for that?
The estate is. So there's two types of debts in sort of the estate context. There's the joint debts, and that goes right over to the spouse. That's left to the joint debt holder.
So if you had a joint credit card.
That's right.
And they had $10,000 on there.
The bank is coming to you.
Right.
The bank is coming to the other person.
But if that person that we described a moment ago had a business, and they had racked up $500,000 in bank loans.
Yes.
And the business, whatever.
Then it's the net value. So say the estate is worth $1 million, but they owe $500,000, then we're only dealing with $500,000.
But say there was more money owed than was available. Then
the estate is essentially bankrupt, so there's nothing to be claimed against. And we do see that circumstance. People can set up their estate planning on purpose so that there's nothing inside of their estate.
Right. It's interesting because I can see the parallels now.
Yes.
But they're not exactly the same.
They're not exactly the same, no. So it sort of informs it, but it's not where the analysis ends. There's way more considerations in the estate litigation and the wills variation specifically to do with that. But it definitely is a piece of the law that needs to be sort of accounted for.
And we talked in the last segment about tax. So the first person, when someone passes away that gets paid, is the tax man.
Exactly. Yes.
And can that get dragged out for a long period of time fighting with CRA?
It can, and we see there's sort of unusual tax issues that can come up. I've had an old German pension that was paid to a gentleman over several years, and he was not required to pay tax on it at the time, didn't pay tax, but then the executor learned that, in fact, he is now obligated, and the German government is working with CRA to collect that tax from his estate now.
Is CRA flexible in your? Do they come at it as a pragmatic approach? Well, let's get this amount, or do they go after everything they're due?
I do not practice tax law. That is a very, very sort of complex area. So we don't deal with tax law. So we refer out to accountants and tax lawyers when dealing with CRA.
But you don't go to court on behalf of the estate against CRA?
No, we don't.
Okay, all right. So what other ways does family law affect wills and estates?
So in the same context I was talking about before, the wills variation matter, sometimes people we find in blended families, for instance, or maybe they get married later in life, they would come and have a cohabitation or a marriage agreement drafted because they're concerned about
otherwise known as a prenup.
That's right,
okay,
prenup. Yeah. And what we see is that they can make decisions about how they want their assets to flow on a breakdown of a marriage. Now, say they don't get divorced, but they pass away and they've left a will that echoes what that cohabitation or marriage agreement says. So it might say, I'm only going to leave this person $100,000. These are the reasons. They both sign a cohabitation agreement or a marriage agreement about that. And then when the person dies, way later on, they leave them only the $100,000. Now that spouse can still say that that isn't fair and apply to vary the will. And we see that the court takes into account that cohabitation and marriage agreement. They're going to look at the fact that these people sat down, even if it was, 5 years, 10 years, and look at it and see how that affects the decision.
So does that prenup, to use a loose term, kind of trump that? Or is it?
It's only one factor. So estate litigation is an interesting area of the law because there are so many moving parts. There isn't ever sort of a trump card that we say, oh, there's a prenup, so never mind, you don't have a claim. It's just one factor that the judge can take into account.
But what I'm getting from the discussions we've had is that, I mentioned, is CRA, are they pragmatic? But it seems like with this wills and estates that there seems to be this sort of ebb and flow that what's best for people is not cut and dry. And it seems that a good argument made on compassionate grounds can actually go somewhere for somebody.
It can. It is a very nuanced area. There's not very many people that practice in it for that reason. And that's why estate planning is so important. We see this sort of, if it's not planned out properly, what can happen. And when we're talking about estates that drag on for years, estate litigation does as well. So it's not a fast-moving process by any means.
And just like divorces, the old joke is the only winner is the lawyer.
Absolutely.
And you have this as well with estates.
Yes. The legal fees can be, tens of thousands of dollars. And I think we all know nobody wants to imagine their hard-earned money going to that. Mm-hmm. And so if you can avoid...
You do. I don't mean to put you on the spot.
Well, it's not just about the money. It's about the files. But absolutely. It's not what people want. So they can do proper estate planning, and hopefully they don't end up in court for 5 years where their families sort of, at each other's throats.
Yeah. All right. We're going to take a quick break. And when we come back, we're going to continue our conversation with Leah Donaldson, Senior Associate at McQuarrie LLP, combining the two, wills and estates and family law, next on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.